and say good afternoon, everyone. My name is Whitney Stoll. I'll be the DC host for our August webinar with our guests Jessica DeHoffman and Tracy Pruitt with their program presentation. How do I get paid when they stop paying? So strategies for construction contractors. Joined by me is Samantha Long and Bree Beal, who will be behind the scenes moderating our webinar today and will also be monitoring the chat. So we have over 70 registered participants from all over the world, and they're ready to learn about today's First Friday webinar. In today's webinar, the team from Pierlo Mazza will explore practical legal strategies to help construction professionals protect their payment rights and resolve disputes before they actually escalate. But first, I'd like to welcome you all and introduce you to the DC Post First Friday webinar series, which is provided to you through SAME's commitment to offering the AEC community effective training, development, and networking programs. The DC Post is helping sustain the future of the profession with these monthly education-focused sessions that are aligned with SAME's strategic goals, really to drive partnerships, deliver solutions, and develop people. So thank you all for joining us here today. And please use the chat to introduce yourself, share your LinkedIn profile, any contact information with everyone and throughout the program today. Ask questions in the chat so we can address them during the Q&A portion at the end. This is a new platform for us, Adobe Connect. You can chat with everyone or even send messages to the host, presenters, or to each other throughout the webinar. We are recording today's session, and we will post a video on our YouTube channel later on. A copy of the slides, as well as your PDH certificate, and the opt-in list of attendees will be available to download at the end of today's webinar. And we'll also email you a copy as soon as the webinar ends. So just look for an email labeled document delivery in the subject line with your downloads following today's webinar session. So we are excited to provide you with an hour of education, virtual networking, no matter where you're calling in from. We'd also like to take a moment to thank the DC Post First Friday sponsors, Fox Rothschild, KCCT, Parsons, and Stantec. We truly appreciate your support, and we're definitely grateful for your generosity by making this webinar series possible for our members and our SAME community. If you're not already a DC Post sponsor, we'd like to support the Post with an annual sponsorship. We'd love to be able to add your name to the slide for future programs and events this year. Annual Platinum sponsors and First Friday sponsors help support this webinar with free registration for SAME members and full-time students. So please visit our website for more information about sponsorship levels and how you can get back to the SAME community with your through your DC Post sponsorship. And now it's time for the main program. So please note this program will provide one professional development hour from the DC Post. And I'm not going to read through the learning objectives on the slide since most of you have already seen these same objectives when you registered. Instead, I'm going to introduce you the speakers in just a moment. While I do the introductions, if you haven't done so already, please use the chat to introduce yourself, share any contact information, your LinkedIn profile, where you're calling in from. This is your webinar series to help you learn about the special topic, as well as expand your business network as well. And please use the chat throughout the program to share comments, ask questions. If there's a particular slide you'd like to talk about, share that information in detail in your chat. We'll answer questions at the end of the program. You will not be able to save the chat, so be sure to take any notes of everyone you want to reach out to after the session ends. And now I'd like to welcome our presenters for the August First Friday webinar, Jessica DeHoffman and Tracy Pruitt. Jessica is a construction law expert who helps contractors resolve payment disputes and navigate complex claims. And Tracy Pruitt advises construction firms and government contractors on compliance, bid protests, and contract disputes. So Jessica and Tracy, thank you very much for being here. Really appreciate it. And now I'm going to turn the program over to you.
Thank you. Thank you for having us. Welcome, everyone. We have a lot of information to get through, and we'll try to do it very quickly. So, we don't want to overwhelm you. If you have a question or an issue, please put it in the chat, and we'll try to get to all questions at the end. As I know, Tracy and I work in the construction group of Plera Mazza. Plera represents a host of government contractors and commercial businesses. I would say the firm's focus has largely been government contracting, but that's not exclusively what we do. I represent contractors, subcontractors, and suppliers in private and public projects, including state projects, county projects, and from the beginning, from contract drafting through claims, and also helping clients navigate, procurement issues, delay claims, and everything you can imagine that can go wrong or right on a construction project. And Tracy and I work together quite a bit. She does a little bit more bid protests, but we work with a great team here at PM, from everything from labor and employment, which comes up a lot in construction, to complicated joint venture agreements and teaming agreements between small businesses and mentor proteges. So we work with a great team here that help the construction industry in general. Of course, Plera Mazza does not do just construction. They do all things government contracting, from services. But Tracy and I are going to focus on construction today.
Yeah. And I'll put a quick little plug in that another particular strength of our firm is we have a great practice focused on the small business programs, 8A, women-owned small business. I saw some people in the chat that may fall into some of those categories. So that's also another area that we do a lot of advising on. And we'll kind of keep that in mind as we go through the program, because we're going to try and talk about everybody from the general contractor level to subcontractors, suppliers, the various different roles that can come up on a construction project, and how you can get paid when they stop paying. All right.
So, and this slide is not limited to, and I understand a lot of folks on this call may be focused on government, particularly federal procurement. The common reasons for non-payment, this list is relative to all construction, whether it's private construction or federal or state construction projects. These are some of the reasons why you might not get paid: defective performance, delayed performance, funding issues, particularly funding issues on private projects, although now we're starting to see some funding issues in the federal arena, change order disputes, invoice disputes, including incomplete documentation. We see a lot of times that the percentages of completions may not match up on construction projects, and that will hold up payment. Disputes over allowability of costs, that comes up a lot in federal and state procurement, but it also can come up in private projects. Non-compliance with contractual obligations, and that is both federal, but particularly it also comes up a lot in private projects, where the contractual compliance with contract obligations will drive a lot of invoice payments. Change order disputes, we've already mentioned. Default, if you're in any type of default, have been in default, or teetering on default, that's definitely going to hold up payment. Regulatory non-compliance, that comes up both in the private and the public forum. That could be everything from licensing. I had a client recently that hired a bunch of unlicensed contractors for a state procurement project, and that held up payment until they had a licensed contractor go in there and basically not redo the work, but check all the work and get approvals. Pay if paid and pay when paid clauses in subcontracts will definitely hold up payment. And that we could do an entire topic on pay if paid, pay when paid, where they're enforceable, where they're not enforceable, and how it may or may not impact your rights to payment. But those are important clauses that you want to review, particularly if you're a subcontractor. Failure to pay your subcontractors or submit waivers for your subcontractors. I know when I represent general contractors, we hold up payment all the time for not having the requisite waivers. If you're a general contractor, you need those waivers to protect your bond on public projects, and on private projects, you'll need them to prevent mechanics liens or any claims against private bonds. And then, of course, the famous back charges. If you're being back charged for a particular project or failure to perform on a project, that's going to hold up payment. More and more, we're also seeing where contractors are trying to back charge subcontractors for jobs unrelated to the job for which you're seeking penalty. There are state laws that may not allow that. Prompt Payment Act laws in various states, including Pennsylvania, will prevent that kind of cross collateralization of back charges. But these are some of the reasons that will be alleged, at least, as to why you're not getting paid.
And I'll put a plug in too to some of the Jessica kind of hinted at this. A lot of those reasons for not getting paid come back to the terms of your contract. So this is just a quick plug to say that the first step in making sure that you'll get timely paid on a contract is ensuring that you review those provisions. Make sure you're aware, you try to negotiate the pay if paid, pay when paid. We're seeing a lot of provisions in contracts allowing the general contractor to back charge for, like Jessica mentioned, other projects. Those are things you need to be aware of, try to negotiate ahead of time, and sort of head this off before the project even gets started.
That's right.
As a general contractor, we're going to kind of start there, start at the top and kind of work our way down talking about these different subjects. But like she said, it really depends on the type of project, where it's located. There are different rules for federal projects, different rules for state projects, and then certainly different rules for private projects. So your remedies for non-payment are going to first and foremost be driven by the contract. Um, uh, to my point earlier, you want to carefully review that contract, understand what the provisions entail. If it's a federal or a state project, you also want to make sure that you're aware of what the applicable federal rules are governing that contract, the state rules. And so all of those can really kind of change what your remedies are. But those are the first places to look. In terms of private contracts, you want to be even more careful about negotiating them because you're going to have a bit more negotiating power. With state contracts, federal contracts, oftentimes you're going to be bound by the laws and regulations that govern those. Private contracts can be more of the wild, wild west. So you may have more power in negotiating them, but you also want to be aware of what the state laws say about which provisions are permissible. So just because your contract says something, depending on the location of the project, depending on which state law has been selected as applying to that contract, may influence whether that particular provision can be enforced or not. So, quickly to go through some of these construction contract traps. Um, Oftentimes we see no damages for delay clauses in there. That's really important. If they've got a clause in there that says for delays, you can't recover any of your costs, you can at most recover time. You want to be aware of that. Um, there's also clauses about waiving lien rights. Jessica, did we get you back?
Yeah, can you hear me now?
We can hear you now.
Okay, I don't know why when I switch to make the screen bigger, it keeps cutting off my audio, and I don't know why, but I'll leave it smaller. So I'm going to get a little closer to the computer. I apologize, everyone, for that technical difficulty.
Yeah.
Um, so construction, just make sure you're reviewing your construction drafts very carefully. If you're in the private sector, they are largely going to be driven by the state law in which the project is performed. There are a lot of states that have anti-choice of law, meaning you can't apply the law of another state, anti-venue laws that won't allow disputes to be tried outside of the state of the project. It is very important you know the laws of the state in which the project is located when you're negotiating the contract. Some states don't allow pay if paid clauses. Some states don't allow waiver of lien rights. Some do. So it's very important to be aware of it and consult a counsel, especially if it's a large project, on contract negotiation. I know when I'm negotiating a contract, it's very easy for me to go back to the other side and say, well, this provision you have is against Texas law. Indemnity provisions, they have, there's a lot of states that have indemnity provisions that prevent you from having to indemnify someone else for their own negligence, but you'll see those clauses in a lot of construction contracts. So when looking at payment clauses in a contract, you want to make sure you're addressing and carefully negotiating and understand the law surrounding some of these clauses. And if you're a general contractor, you want to keep these laws in mind too as you're negotiating your subcontracts. Because we all know we want to push that risk down, but sometimes the law doesn't allow you to do that. Okay, let's talk about private projects really quickly. I know that's not the focus of what a lot of people do on this call, perhaps, but I think it's important to go through them. In private projects, when you haven't been paid, one of the most important resources you have are the mechanics liens in all states. So mechanics lien laws, basically you can't put there's no bonds in private projects unless they're private project bonds, which are a little different than your Miller Act bonds. But every state has mechanics lien laws which allow you to put a lien on the property if you're not paid. So if you're a general contractor and you're not paid, you can lien the property. And in the 25 years, I've only put one property up for auction that we liened here in Maryland. It is such a powerful tool. You will typically get paid very quickly. Sometimes it's not short of litigation, but most people will get you paid because they don't want you to foreclose their property. Be careful because lien laws, they have strict deadlines. These are um, statutory requirements that have to be strictly complied with. A lot of times they have notice deadlines. It could be 90 days from your last day on the job. Um, Make sure you're aware of these deadlines and you meet these deadlines and file the forms that you need to within the timeframes, or you will lose your lien rights. Um, you can also, if you're the general contractor, of course, sue the owner. And in that case, you're breach of contract, unjust enrichment. There's also a lot of Prompt Pay Act violations laws out there. Prompt Pay Acts don't just apply to public procurement. There's also Prompt Pay Act laws that govern private projects and require that contractors be paid within a timely fashion. And a lot of those provide for interest and attorney's fees. So you want to be aware of the state laws governing the project to see if you have other causes of action against the owner. Okay, now let's get into the federal world. In a federal project, if a general contractor is not paid, you under the Prompt Pay Act, you get interest. It's automatic and it's subject to the interest rate that's set by the Department of Treasury. I put a number in this slide. You can call the Department of Treasury to get the applicable interest rate. You don't need to demand interest. It is payable without regard to demand. If the interest is not paid within 30 days, the interest is then added to the principal and interest is then accrued on that total. It's a compounded interest, which is quite not punitive, but it's quite an incentive to get the government to pay. Interest compounds every 30 days until the total amount due is paid. Now, the government's Prompt Payment Act interest is actually severed by the occurrence of one of two things: that a Contract Disputes Act claim is filed, or more than 1 year has gone by. Small businesses can get accelerated payment goals of 15 days if a specific date is not set per your contract. So if you're a small business, you might want to look at your contract to see if there's a date other than the 15 days. If not, you might be entitled to interest if you're not paid in the 15 days. There's also an additional penalty that a contractor that's not paid promptly is entitled to under the Prompt Payment Act. If the agency pays your invoice, but not the accrued interest, which it's supposed to do automatically, you don't have to demand it. You can obtain an additional penalty, but you have to demand it. This is the penalty interest. It's not the interest. Remember, the interest you don't have to demand, but the penalty you do. So if you're not paid the interest within 10 days after which the invoice payment is made, you have to make a written demand for it, not later than 40 days. And then you're entitled to an additional penalty equal to the percentage of the late payment interest penalty specified by the regulation. The demand has to include the amount of the late payment interest on the invoice. You have to attach the invoice and provide the date of payment. And the additional penalty is equal to 100% of the original late payment interest penalty, but it can't exceed $5,000. So it's an additional penalty that you can obtain from the government if they don't pay your interest. And the additional penalty interest is never less than $25. Okay, Prompt Payment Act does not apply to financing payments. And this is under the FAR Clause 52216(7)(a)(2). And what are contract financing payments? Well, there's a list of the types of contract finance payments that the feds determine are not subject to the Federal Prompt Pay Act. Payments that are made under a time and material and labor hour contracts they're considered contract financing payments. Progress payments are considered financing and are not subject to interest penalty provisions of the Prompt Pay Act. Commercial products and commercial services are not subject to it. Performance-based payment, if it's a performance-based clause, it's not subject to the Prompt Payment Act. And payments by a third party are not subject to the Prompt Payment Act. Okay, so what happens when you're not paid? You can increase your interest recovery if you wait. You're entitled to Prompt Pay Act interest for 360 days, after which you can actually file a Contract Disputes Act claim. If you wait, you get all that interest. If you do it earlier, if you file a Contract Disputes Act claim, you're going to sever your Prompt Payment Act interest. Remember, we talked the two things that cut it off, either 1 year or a CDA claim is filed. If you really want to capitalize on the interest, you can let it go almost a year, then file a CDA claim, and then you get CDA claim interest. How do you turn a regular invoice into a CDA claim? Well, there are two types of payments. There's routine and non-routine. Routine payments are not typically, an invoice is considered a routine request for payment, and it does not rise to a CDA claim because it has to have a dispute attendant with it. For a non-routine request to turn into a dispute, all you have to do is serve a written demand seeking as a matter of right the payment of the money in that sum certain. And then once you do that demand for payment, if there's assuming there's no pre-existing dispute, you need to send a letter to the CO stating that the continued non-payment is disputed, request a final decision on paying the invoice, and if the amount includes is in excess of $100,000, you need to have your claim certification as required by the contract. Once you do that, and it doesn't have to have really any particular formal use or particular wording, just needs to be clear and an unequivocal statement that gives the contracting officer adequate notice that you're creating this claim and the basis for the claim. And then once you're not paid, you can start a Contract Disputes Act and file a claim. And then you're entitled to, under that, your unpaid Prompt Payment Act interest is a separate claim and is actually included in the claim for non-payment in your Contract Disputes Act claim.
And I'll jump in here because there's been a lot of different case law over the years, courts interpreting what has to be certified in that claim to go forward. If you're going to have to go to one of the boards, you're going to have to go after the government for payment on that. There are a number of cases where the courts have said, if you don't certify the specific amount, if your calculation changes, if the way you characterize your claim changes, they've rejected certain claims and said that's not a claim that was certified to the contracting officer. It's not right for us to decide on because the contracting officer didn't have a chance to review that. Recent case law has kind of loosened up on that a little bit, but you do want to be a little bit careful about the amount and the types of claims that you certify to the contracting officer, because there is always a risk that if you did not certify it to the contracting officer and later you need to change the nature of the claim that you're making. Let's say you're making a delay claim and then after the fact you find out it's a differing site condition. If that was not certified and brought to the contracting officer's attention, there is some risk that a court could say the contracting officer didn't issue a final decision on this. It's not right. We can't consider it.
Okay. So just make sure you're certifying it. And that's largely also going to be dictated by the amount of the claim. But for routine payment of invoices, if you're not paid, you just need to send that notice. Okay, so CDA interest. So we talked about the Prompt Payment Act interest, which is now part of your CDA claim. And once that non-payment turns into a claim, you get interest on the unpaid interest and the PPA interest on unpaid invoices. So you can see how your interest is going to start to compile. The difference between the CDA interest and the Prompt Payment Act interest is the CDA interest is simple interest. It does not compound. And the interest rate adjusts every 6 months. It also is payable until the claim is resolved, whereas Prompt Payment Act interest is limited to the 360 days. Okay, so that's interest. If you're on a federal project and you're still not paid, the government's in breach of contract. The government has two primary obligations: to act in good faith and to timely pay its contractors. And a failure to pay is a breach of contract. It has to be a material breach of contract, however. And whether something is a material breach of contract depends on the amount of time of non-payment and the amount of non-payment. If you're a contractor and you're coming to me and saying, I've not been paid, I'm going to terminate and walk off the job for default, and I don't care if you're in a private job or a public job, I'm often going to look at that very carefully. Because that is a very dangerous thing to walk off the job. In this case, in the federal context, if you're owed $5, is that a material breach? If the payment's been pending for 90 days, is that a material breach? That's where you need to consult an attorney, because what are your options when there's material breach? Well, you can continue to perform and essentially waive the breach and then seek damages at the end for interest when you haven't been paid. The other option you have is to discontinue performance and claim that it's a total breach of contract, it's material, and it excuses you from further performance. If you're wrong there, you're in breach. That's the problem when you discontinue performance. It is a very risky thing to do. And many contractors won't do it. So consult counsel before making a decision to discontinue performance, and that's on any job, but it includes the federal projects. When you discontinue performance, you're entitled to payment for the performance you had prior to discontinuation. You are entitled to lost profits on the work that's not performed, and you may be entitled to administrative costs, assuming that you've contemporaneously track them and they're allowable under the FAR. Consequential damages are not going to be recovered.
I'll jump in here on another one too, to Jessica's point about when a breach is material. Generally, it's not going to be material if it's small amounts or there are small delays in payment. Another thing to keep in mind is if you're consistently getting late payments, courts have sometimes considered it a waiver if you don't bring that to the attention of the contracting officer. Maybe your payment terms are 30 days, they're consistently paying you at 45 days. You want to bring that to the attention of the contracting officer. You want to continue to assert your right to be paid in a timely manner, because if down the road you need to make that claim and say the government was in breach, maybe a termination that they imposed on you was a wrongful termination, if you've not asserted your rights during the course of the project, some courts have considered that a waiver.
So the other thing that, and I've had this come up once where there were some insecurities that the government wasn't going to make any further payments on the contract. It ended up getting resolved, but there's something called government repudiation, where the government, maybe the contracting officer, makes a statement that, hey, we're not making any more payments on this job for whatever reason. If that happens, you need to send something in writing to the contracting officer that asks for what we call adequate assurance that the government will continue to perform despite the statement made by whomever, the contracting officer, that payments weren't going to be forthcoming. If the contracting officer fails to respond or affirms the statement, then the repudiation of the contract is confirmed. This is a breach by the government. And the contractor has the same two options that we went through. You can continue to perform and you waive that repudiation, or you can assert an anticipatory breach, cease performance, and seek damages for the material breach. Remember, consult counsel before you stop performance on any contract. It is a dangerous thing to walk off a job, whether you're a subcontractor, a supplier, or a general contractor. Okay, I'm gonna turn it over to Tracy.
All right, moving on to subcontractors, and we're going to talk about private projects first. To some extent, we'll kind of hit how this would apply to a general contractor as well. But as Jessica mentioned earlier, on a private project, subcontractors may have a right to file a mechanics lien. Now, for a mechanics lien on a private project as a subcontractor, one of the first things that you want to do is make sure you understand what the state laws are, because with a general contractor, obviously the owner of that project, the owner of the land, knows that the general contractor is working on it. They may not be aware of who all the subcontractors are. And so in many states, there's a requirement that you give them notice that you're a subcontractor and you're providing services on a particular project. Sometimes the time period for doing that is very short. Some states, they say you have to give notice to the owner within 20 days of going onto the site and performing there. So you want to make sure you know what the mechanics liens laws are, what kind of notice you're required to give. Um, there are also trust fund statute violations. I haven't dealt with this as much. Jessica, do you want to kind of hit what the trust fund?
Yeah. So trust fund statutes are interesting. There are statutes in a lot of states that require that funds on a project are held in trust for the so if I'm the general contractor and paid by the owner, I hold those funds in trust for the subcontractors and suppliers performing work on that contract. If I use those funds for something else, robbing Peter to pay Paul, that can be a trust fund violation. And there, in a lot of states, it can be criminal. There can also be personal liability for the persons within the organizations that are controlling those funds. So it can be very powerful to assert a trust fund violation against a contractor, and especially if there's criminal potential for criminal responsibility. So make sure you consult counsel if you're not paid on a private project, and so that you know all the available tools you may have to push back.
Thanks, Jessica. So again, like we say on here, the big thing is know the state's laws that apply. Going back to an earlier point, usually that's the state where the project is occurring, but make sure you consult your contract and find out if the contract included the selection of a different state law. Sometimes they'll even
And
include
I,
one
yeah,
saying,
and jump in on this. Make sure you know the state. If it does allow the law of another state to apply, don't assume that that state's laws are going to be great for you. Consult counsel, because there are some states where I would not want to try a construction case. I there's some notoriously bad venues and laws that don't necessarily help subcontractors. So make sure you consult counsel before you just summarily agree to the application of a particular state's law or a venue. You don't want to be what I call home cooked in some small town where your general contractor is, a big employer.
yeah, absolutely. So keep those in mind when you're looking at the contract. When you're not getting paid, go back to your contract, look at that. Don't just assume that it's going to be governed by the laws of the state where you are or where the project is. Like I mentioned, I'm going to try and speed this up so that we can finish on time here, but some states do have really complicated notice deadlines. Texas is an example. You want to know what those are. You want to know what those are at the beginning of the project. The time to be thinking about how you will make sure you get paid is at the beginning of the project when you're negotiating that subcontract, and then have that information on hand and readily available so that when things start happening on the contract, if you're getting behind, you know what your options are going to be. Usually the deadlines run from the last day of your performance or the leaner's performance on there. Punch list work oftentimes does not count as that. So it's the last day of normal performance is when your deadlines usually start to run. But again, you want to look at the state rules. Um, Not all states protect all tiers. So I mentioned that if you're a subcontractor, the owner may not even know you're working on the project. They've hired the GC, they don't know, they don't care who else is working on it. Uh, a lot of states do protect that first level subcontractor, but there may be the notice requirements that you have to notify the owner within a certain period of time of starting performance on the job that you are a subcontractor on it. But as you get further down, subs, suppliers, other people working on the project may not be protected and may not have a right to file those liens. So you want to make sure you know what the particular state's rules are on how far down that lien protection works or applies. So, for example, DC provides no lien rights to second tier subcontractors. Uh, Most states don't allow waiver of lien rights, but you do want to, again, look to your contract and then the law of that specific state to make sure you know when waiver is considered valid. Make sure you know what you're waiving. Look at the pay apps too. You know, it's common on pay applications to include standard language where you're waiving all claims you have, waiving all lien rights. You know, when you're submitting those pay applications, if you're not in a position to waive all of those rights, if you have outstanding disputes, if you have outstanding monies due, don't just sign those. The pay applications often don't just apply to the particular period of performance or work included in that pay application. Oftentimes they'll waive things going back in time. I've even seen some that try to waive your rights going forward. That's probably not going to be enforced by a court, but still, I never like to advise clients to sign something and count on the idea that a court is later going to invalidate that. Don't sign things that you're not willing to agree to. Um, so, as we mentioned before, there are states that have these trust fund laws that can create other penalties. Like Jessica mentioned, that can be really powerful in terms of encouraging uh, whoever you have the contract with to pay you. All right, as a subcontractor, like we said, your remedies really depend on whether the project is private or public. First place you're going to look is your subcontract. Carefully review it and negotiate it. We've kind of already talked about these, but here's a list. I think you're all going to be provided with a copy of this presentation. These are some of the really killer contract provisions dealing with payment, dealing with when you can get damages, what types of damages you can get. I've seen contracts that allow money but not time. Um, you know, you want to just be aware of what your remedies are. Are you waiving lien rights in that contract? What are the provisions of the change order? How quickly do you need to notify the general contractor that there's been a change, that you're incurring additional expenses? Some contracts have very, very short time periods saying that you have to put them on notice, and they may also have really onerous requirements about what needs to be in that notice in order to preserve your right to make a claim for additional costs. Um, so know your contract provisions, negotiate them hard. On private projects, your main option, aside from liens, is also going to be litigation against the contractor. You can make a breach of contract claim. Sometimes you can also make equitable claims for unjust enrichment. Um, Again, you want to look at your contract clauses because oftentimes when you have these disputes, your contract is going to require you to continue performance. To Jessica's point, walking off the job, while feels very satisfying in some instances and feels like a really necessary thing to do when you're not getting paid, we would always advise you pick up the phone, call an attorney, get a little quick consultation first, because if you're wrong, if you don't succeed in court, that can come back to really bite you. So we can help you come up with creative strategies to try to get payment, lessen your obligations on that contract, but be careful about just walking off performance. Um, some states do allow you to suspend performance if you're not paid. For example, in Pennsylvania, the Contractor and Subcontractor Payment Act protects contractors and subs that aren't paid. Um, if you're not paid, you have a statutory right to suspend performance without penalty until you are paid. So there may be protective state laws as well. There could also be private payment bonds that apply. You're going to have to look at the terms of those bonds, read them carefully. Again, notice and deadlines on the bonds are strictly construed. Those bonds are contracts. You can't miss the deadlines. If the bond says that you need to submit on a specific form, if it says you need to include 15 different pieces of information, if you don't comply with every single specific requirement of that bond, oftentimes the sureties will just ignore your claim. They will say they didn't get it in time, and you may not have validly asserted that claim. So know the bonds. There are standard forms, but one of the problems is sometimes people change those forms. If you don't get a copy at the outset and your contractor knows that they're not paying you, you may have a hard time getting a copy. So I always recommend that at the outset of a project, when you're negotiating that subcontract, if there is a private bond or even a public bond, Miller Act bonds, get a copy of that from the outset so that you have it, you know who the surety is. There are also practical problems associated with that. In addition to trying to find a copy of the bond, some states have filing requirements. So you want to know what the state's requirements are to be able to enforce your bond rights. That can apply even to for these private bonds. In terms of lien bonds, those are filed with land records. Typically, again, every state has different laws, different time period requirements, and that can replace a lien against a property with a lien against the bond. Typically, the lien law and notice requirements still apply. So consider that as another option. If you're a subcontractor on a federal project, it's a little bit more clear because you have federal regulations that are going to be flowed down, although from contract to contract, different federal regulations apply. Oftentimes, subcontracts include a provision that says all the provisions of the prime contract flow down. Make sure you get a copy of that prime contract. Make sure you know what federal acquisition regulations apply to the prime contract and what is being flowed down to you. If you're not getting paid on a federal project, and it's, like Jessica talked about before, there's that Prompt Payment Act. That requires the contractor to pay the subcontractor within 7 days of receiving payment from the government. But that provision has to be incorporated into the subcontracts. It's a mandatory flow down provision. Make sure that your subcontract doesn't purport to waive that or anything along those lines. You don't have a private right of action for Prompt Pay Act violations. It just entitles you to those interest penalties. Now, the contractor is entitled to have retainage and withholdings. They require the contractor for withholdings. Contractor has to notify the CO of their reasons for withholding payment within 7 days of the withholding deadline, or within 7 days, and describe the reason for that withholding. If they haven't done that, that can be another way to kind of encourage the contractor to make payment on things. They should be keeping the contracting officer aware of withholdings. Retainage is usually a standard percentage that's going to be specified in your contract, and that's allowed. They can hold retainage until closeout is completed on the project. Also, Miller Act on a federal project. Federal projects require, the Miller Act requires payment and performance bonds because you can't lien federal property. So the Miller Act has specific rules. The deadlines for a first tier sub don't have to give notice. You have to file a complaint against that bond within 1 year of your last performance. And again, your last performance is probably the last day that you worked typical, within your normal scope of work. It's not coming back for warranty work. It's not coming back for punch list work. So keep that deadline in mind. If you're a second tier, you have to give notice to the prime contractor within 90 days of the last day you performed on the contract. So you want to make sure that that prime contractor has notice that you worked on that and that you may be asserting payment bond rights. Litigation, again, has to be commenced within 1 year of your last day of performance. Third tier subcontractors are not protected under the Miller Act. Miller Act can't be waived. So if it's a federal project, it applies. But contractors often have clauses that can be read as an attempt to waive rights. So, you want to look at those carefully. Another thing that I've seen recently is the Miller Act applies to construction projects. As the government has gotten more creative in how they're going out and soliciting work, we have seen them solicit construction work as sort of an ancillary part of a non-construction project. In that case, there may not be bonds on that project. So, for example, we have a client who was a subcontractor on a federal project, assumed that there would be bonds because it was construction, disputes arose, and come to find out that the main contract, the prime contract, is not a construction contract and there were no bonds. So, again, verify that up front, get a copy of those bonds. All right, quickly to finish up here. You've got your subcontractor on a federal project. You do have a breach of contract action against the contracting party. So even if you're a second, third tier sub, a vendor, a supplier, you want to review the contract again for those dispute provisions. Consult an attorney before continuing performance for all the reasons we've talked about. And your state law is going to govern that. It's not necessarily going to be governed by federal law if you are just bringing a breach of contract action. Some states have laws that require application of that state's law for disputes arising when the project happens there. They won't allow a separate choice of law. So it might be the project is in Maryland. Your contractor has said choice of law of California. If Maryland has laws that say, nope, if the project's here, we have the right, our laws apply, you may be able to dispute the choice of law provision in your contract and have the local laws apply, depending on what's going to be more favorable to you. So be sure you're following all of the claims and notice procedures and time requirements. States also sometimes have prompt pay acts. A state prompt pay act is going to usually be similar to the federal act, but there could be different deadlines, there could be different requirements. So check on your state law. States also, many of them, most of them have little Miller acts that require a payment bond on state projects.
Well, and all of them do. Every single state has a little Miller. Every single
right. So the deadlines are going to vary though by state because they are flowed down from the federal Miller Act, but every state likes to put their own little touch on things. So claim notice deadlines can vary. You want to know your state law and contract to see if those rights can be waived. There are also stop payment laws. Some states have laws that allow an unpaid subcontractor to send the owner a notice of non-payment, and then the owner can stop payment to the contractor, kind of like those trust fund laws. So that can be a very powerful tool to notify the owner you're not getting paid. Make sure you follow the notice requirements. We're like a broken record on this. But the main way to recover is a breach of contract action against the contracting party if there is not a bond, if you cannot go to the owner and get paid that way. For county and city contracts, the Miller Act, Little Miller Act for the state likely applies. All right. We ran a little bit over, but we're going to turn it over to questions.
Well, no, I definitely I appreciate that, both Jessica and Tracy. Thank you very much. So, hey, if anybody has any questions, we do have time for a few. So please enter it into the chat if you'd like to get it across. We do have a couple already in there. I'll turn to the first one already. It's from Harpreet. It says, they ask, I am a sub to a subcontractor who was hired by the main GC on a federal project. GC has paid the subcontractor, but I have not been paid. Is there anything that I can do?
So I could take this. If you're a second tier sub and it's a federal project, a construction project, there should be a bond. If you're not off the project more than 90 days, you need to send a notice under the Miller Act of non-payment to the GC, and you have a claim under the bond, and that's very powerful. So you're going to want to get a copy of the bond, which you can get from the contracting officer. You have to, the Miller Act requires the contracting officer to provide a copy of the bond. You usually have to submit an affidavit, but I've gotten the bond, a copy of it, not a certified copy, just by picking up the phone and calling the contracting officer. So you definitely want to get a copy of the bond. Send notice. If you're off the project for more than 90 days, it is likely that you do not have any bond rights. You are going to be limited to suing your contracting party for breach of contract. The other thing is if there has been no payment, that flow down Prompt Payment Act flows all the way down. So you're entitled to interest. You need to notify the GC, and you can copy the contracting officer that you have not been paid. And oftentimes lately, I've noticed the contracting officers getting involved. So be proactive. If you're hopefully you're still within 90 days of last being on site, reach out to your attorney or reach out to counsel to advise you on filing a claim and ultimately a complaint against that bond.
Great. Thank you, Jessica. This one comes from Angie. It's a long question, so just bear with me. Angie asked for it. So we work mostly in the GC role for primarily for federal contracts. So what tends to happen to us is there's a gray area at time of approving schedules of values. The AF 3000 approves of submissions, etc. So we do that first before we are allowed to submit into the appropriate invoice system. Sometimes this process is 60 plus days, meaning that we are cash flowing that project. Are there any actions that we can take to compel approvals to enter invoices into that system?
So I don't think I understand completely that there's a schedule of values that has to be approved before you submit the invoice. I guess that's what it is. The issuance of the invoice, I would argue, not the acceptance of the invoice into the system, is going to require the interest. I would start demanding the interest and start sending letters to the contracting officer. And that may actually get their attention because I'd have to look at it. I don't know that the acceptance into the system is what triggers the Prompt Payment Act. But I'd have to look a little more carefully. I'm not sure what system it is. The one thing that would trigger, you're not entitled to Prompt Payment Act interest if you don't submit the invoice with the requisite information. So if the invoice requires, backup for the interest, like a schedule of values, and you don't do that, the invoice isn't due until that condition precedent is met. So without understanding your approval process, I'm not really clear on what you could do. If it's a precondition, as long as you're meeting the preconditions, you're entitled to that Prompt Payment Act interest, and I would start making demands against the CO for that.
Yeah,
so
I
let
want
me ask you this one. Jessica, what if the general contractor does not pay the Prompt Payment Act interest?
That's it's funny. I had this just come up on a project, and so the general contractor, that's a flow down provision. They are required to pay you in 7 days. If they don't, they owe you that same interest under the Prompt Payment Act that the government owes. It's compounded. It's all of that. And so you can demand it. Unfortunately, you don't have a private cause of action against the prime under the Prompt Payment Act. Instead, when you sue for breach of contract, that's a part of your damages. But I had a subcontractor notify the contracting officer of non-payment, and the contracting officer is withholding payment from my client right now. Arguably, that's not allowed under the Prompt Payment Act, but the government's taking the position that it's a breach of the contract for failing to file the Prompt Payment Act. So sometimes reaching out and sending a notice to the contracting officer can be a powerful tool.
Got it. Excellent. And then you briefly mentioned this is how can subcontractors obtain the payment bond for a project?
You can request it from the contracting officer. That's something to ask for up front. Ask for these things before you get into a dispute with the party you're contracting with. Get a copy of it when you sign the subcontract or you're negotiating it, but you also can request it from the contracting officer. Like Jessica said, I think the rules require you to submit an affidavit saying that you performed work on the project and requesting a copy of that. But oftentimes it's as easy as just sending an email or picking up the phone. And that can be kind of a subtle way to put the contracting officer on notice that you're not getting paid as well.
Correct. Now, in the private world, I can tell you, general contractors, and it's not to throw any general contractor on the phone into the bus, but general contractors are the principals on these bonds. They're ultimately liable, and they don't want to part with them. They don't want their subcontractors to have them. So asking your GC for a copy of it often will be delayed or they won't provide it to you. In both state projects, private projects, and federal projects, it's often tough to get them from the general contractor. So in state and federal projects, reaching out to the contracting officer or the agency head to get a copy of those bonds will get you pretty far. And when I say state projects, it can be a college, it could be a school. Those are all state funded projects. So I will oftentimes charge a paralegal just making phone calls until I get it. You also can FOIA the information. That takes too long though sometimes. So I usually will charge someone who would just start picking up the phone. A private payment bond in New York, they're required to be filed. In some states, they're required to be filed, but they are really tough to find. And by the time you're aware that there was a private payment bond on a project, you've missed the deadlines for notice. So like Tracy said, if there's a private payment bond on a private project, ask for it at the time of contracting. I can tell you if a bank is going to loan $10 million to fund a project, they're going to require a performance bond and a payment bond. So they exist, they're just often hidden. So,
Got it. Excellent. Well, thank you, Jessica. Thank you, Tracy. We're going to wrap up quickly here, and they're welcome to stay on for a few minutes if anybody has any additional questions. But we really appreciate both your time here today. Definitely a very informative session and breaking it down for us. Definitely had interest from our participants here today. But before we wrap up our program today, I'd like to share a couple of upcoming events that we do have planned. So please mark your calendars for some of the upcoming local post events as well as national events. You can join us next month for our September First Friday webinar, which is the NS Savannah Decommissioning a Nuclear Power Ship in the context of historical preservation. You won't want to miss this fascinating look at how maritime administration balances radiological decommissioning requirements with the need to protect and preserve the NS Savannah, which is the world's first nuclear-powered merchant ship and now a National Historic Landmark. This session will explore how federal agencies tackle the technical, environmental, and historical preservation challenges to prepare the ship for its next chapter. And are you interested in sharing your knowledge on our current educational topics on the First Friday series with our members? So we are accepting presentation abstracts for the winter 2025. Please visit our website and learn more to submit your topic today. And sponsorships are also available to support this popular program. And this fall, you don't want to miss some of the upcoming national events. Let us know in the chat if you'd like to attend any of these SAME national events. You can book your travel now and join SAME at the 2025 Indo-Pacific Regional Summit in Honolulu from September 8 to 10. Learn more about upcoming opportunities from NAVFAC, Coast Guard, and USACE for programs in Japan, Korea, Guam, and other countries and territories in the Indo-Pacific region. Now is the time to book your hotel and register for the SAME Federal Small Business Conference in Phoenix, November 19 through 21. You won't want to miss the largest SAME conference of the year to help you accelerate readiness with fantastic sessions, speakers, and networking to help you build strong partnerships and teaming opportunities throughout the AEC industry. Bria and I will be returning as speakers on our popular series to help you navigate AI and marketing and business development outreach. So we hope you can all join us in Phoenix this fall. But we also have a very busy schedule here for the DC Post. So join the DC Post, Mid-Maryland Post, and DBIA Mid-Atlantic region on Sunday, September 14th for the return of our annual Team River Runner Family Day, kayak and picnic on the Potomac. So thank you to our sponsors, Pannoni and Procon Consulting. So this event is offered free of charge and the whole family is invited. So sign up today and support our veteran community. Our 2025.
Oops, looks like we lost Whitney. Sorry, guys. I will wrap up this for us. Our 2025 annual STEM golf tournament registration will kick off today. You won't want to miss the opportunity to play at one of the three armed services' most challenging champion golf courses. Enjoy a day of friendly competition and camaraderie while we support our SAME DC Post STEM Scholarship Fund. So join us on October 1st, and sponsorships are available. All right, back to you, Whitney.
All right. Hey, thank you for way to come in, Bree. I appreciate that. So now now I'm back. So up as part of our renewed partnership with George Washington University, the DC Post is in the planning process and about ready to open registration for our highly anticipated Transatlantic Energy Security Symposium on October 29th. Join us at the National Press Club for a full day of strategic dialogue, actual outcomes, and global cooperation between the U.S. and European nation as we dive into the future of energy security as well as a partnering conference. More details to come soon, and sponsorships will be available. We also have more events planned for the rest of the year. Please visit our DC Post website to see a full list of our educational and social events for the year. Join us on LinkedIn, where we share industry news, photos, and we continue to build a strong network throughout the AEC industry. And you can also watch a lot of our First Friday webinar sessions on our YouTube channel. And if you'd like to join a global community of 7,000 architecture, engineering, construction, and tech leaders with a DC Post annual sponsorship, you'll have the opportunity to leverage our networks and showcase your firm with visibility and international recognition you won't get anywhere else. Support us with an annual sponsorship, program sponsorship, like this First Friday webinar series, or at individual events throughout the year, such as the upcoming Energy Security Conference. Check out the benefits of sponsorship and support the mission of DC Post and your community today. So again, thank you all for attending our First Friday webinar. Thank you, Jessica and Tracy from PLO Mazza for providing great educational content today for our August First Friday webinar series. If you haven't, download today's documents before you leave the webinar, and you will look out for document delivery in the subject line with the slides, PDH certificate, an opt-in list of registered participants today, and we'll post this on our DC Post website later on this month. You may also get an email from our presenter with more information about what was presented and how you can sign up for their newsletter, and as well as other announcements as well. So again, thank you to our DC Post First Friday sponsors, Fox Rothschild, KCCT, Parsons Corporation, and Stantec. So on behalf of myself, Bree Beal, and Samantha Long, have a great weekend. We look forward to seeing you out at the next SAME event. Thank you.